Hustler is a fascinating case that arises when Jerry Falwell, who created the moral majority, sued Larry Flynt, who was the publisher of Hustler magazine, for intentional infliction of emotional distress. And the question that the case raised was, what First Amendment defenses would a defendant in such a suit have? Reverend Jerry Falwell created Liberty University. He was a major leader of Baptists in the United States. Larry Flynt considered him a mortal enemy because, of course, Jerry Falwell was campaigning against pornography of the kind that supported Larry Flynt. And in Hustler magazine, he did a series of parodies of the advertisements for an Italian liqueur called Campari. Campari had an advertising series called My First Time. And the series featured celebrities who recalled the first time they drank Campari liquor. Flynt published a parody of My First Time, and it featured Jerry Falwell having an interview about his first time drinking Campari, which turned out to be in an outhouse while he was having intercourse with his mother. Jerry Falwell was appalled, and he sued Larry Flynt, making 3 distinct claims. The third claim was intentional infliction of emotional distress. Intentional infliction of emotional distress is a relatively new tort. It says that somebody has intentionally tried to induce in you severe emotional distress through outrageous behavior. The jury found that this kind of advertisement, this parody, saying that Falwell had had sex with his mother in an outhouse was outrageous. So he had satisfied the elements of intentional infliction of emotional distress and was therefore entitled to a judgment under Virginia law. And it's in this posture that Larry Flynt takes the case to the Supreme Court of the United States. And the question before the Supreme Court is, will the First Amendment allow such a suit to proceed? The judgment of the court was the First Amendment protects public speech, which violates community norms. You cannot regulate speech merely because it is offensive, merely because it violates community norms. So anytime you speak to the general public about matters of public concern, and here the crucial word is public, the protections of the First Amendment will kick in. Rehnquist proposes a test of actual malice, which he gets out of the New York Times versus Sullivan case, which is a case about libel. And he says, you can only recover for emotional damages if you show that the speaker, the defendant, intended to harm you and intended to do so through the intentionally false statements of fact. Now, that is a very odd rule because the tort of intentional infliction of emotional distress has nothing to do with false facts. Justice White penned a paragraph saying, I agree with how the court decides the case, but I don't agree that there should be an actual malice test because New York Times has nothing to do with this case. Every community has norms. That's what we teach our children in nursery school. Don't bite, don't spit, shake hands. We teach them how to act as civilized persons. The interesting thing about Hustler is that it suspends those very norms in public discourse. It does that because the public sphere is a place where people from different communities meet each other. So people from different communities have different norms about how one should and shouldn't behave. And what Hustler stands for is the fact that we have not merely a marketplace of ideas, we have a marketplace of communities. We are a heterogeneous country with many different communities. And the First Amendment says that when it comes to public speech, no community can use its norms to censor the speech of people who come from a different community and who abide by different norms.